Darkcast Network, indie pods with a dark side. Hello, and welcome back to Fuck That, and Happy New Year. This week, I spoke with a woman who served on a jury for a murder trial. But after the sentence was doled out and everything was said and done, a month later, she was held in contempt of court for conducting a simple Google search that yielded no results. Before the interview, I'm going to briefly discuss the case as well as the process of criminal trials in the United States. But at the request of Katrina, the juror who I interviewed for this episode, I'm going to be leaving the parties involved in the case anonymous. In the summer of 2019 in Hot Springs, Arkansas, a 57-year-old woman shot and killed her 61-year-old husband who was wheelchair-bound in their home. The woman promptly called 911, and they arrived shortly after 1:30 p.m. Upon arrival, they found her husband lying on the floor with a gunshot wound to his abdominal area. He was pronounced dead shortly after he arrived at the hospital. The now widow cooperated with police, admitting that she had shot her husband, but she claimed it was done in self-defense. According to her, they had several issues with domestic abuse. She stated that day they had gotten into a disagreement, which resulted in him cornering her in the room and she could not get away. She stated that she attempted to spray him with wasp spray as a deterrent, but when that didn't work, she felt that she had to shoot her husband in self-defense due to a domestic incident. She was charged with first-degree murder and she put in a plea of not guilty. A jury of 8 men and 4 women were selected and the trial began in April of 2022. It was noted during trial that her story did not change one single time. On April 14th of 2022, she was convicted of second-degree murder and sentenced to 20 years after just a 4-day trial. But just a month later, her conviction was overturned and a mistrial was declared due to juror misconduct. She was subsequently charged with manslaughter and was again found guilty, but this time she was sentenced to 10 years. According to court records, she did file for divorce from her husband sometime in 2016 and noted in her complaint that they were married in 2008, but they were separated and living apart since 2012. Sometime in early 2018, she had filed a motion to dismiss the divorce complaint, and that was dismissed in its entirety about a month later in early 2018. Criminal trials are something that are constantly discussed in this country, particularly the power imbalance when you think of all of the power that prosecutors have in criminal trials compared to defense attorneys. A criminal trial is essentially the government's opportunity to argue the case, get a verdict, which they obviously hope is guilty, and the result would be a conviction for the defendant. But this also means that the defense has a chance to refute the government's evidence and to offer their own evidence in some cases. The jury then examines all of this evidence to decide whether, beyond a reasonable doubt, the government has proved that the defendant committed these crimes. Absolutely. The jury meets as a group and they consider whether they find the defendant to be guilty or not guilty of whatever crime they were charged with. When a criminal trial is completed in its entirety, it consists of typically 6 phases, which starts with choosing a jury. Opening statements are then given. There is witness testimony and then cross-examination, closing arguments for both sides, jury instructions, and then the jury deliberation and verdict. There are rare cases, for example, a bench trial where the case will only be heard by a judge and a jury is thus not involved. But for the most part, jury selection is one of the first steps. This involves the plaintiff's attorney or the prosecutorial attorney and the defendant, as well as the judge, they question a pool of jurors in a process that is called voir dire. And the purpose of this is just to make sure that a juror's fitness is where it needs to be in order to serve on the jury for this case. And I don't mean physical fitness, I mean, mental fitness. So they want to know about potential biases that somebody may have, or maybe there was an experience that they had in life that may cause implicit bias with a certain kind of trial that they may serve on. So they do this and vet these people throughout that process. Jurors can be excused at this point in stage if their responses show that they are not able to be fair or impartial. And in addition to that, the prosecution and defense may exclude a certain number of jurors through preemptory challenges or for cause. And they can exclude a juror for really any reason that doesn't involve ethnicity, religion, race, and sex, gender. Once the jury is selected, you'll have opening statements, which is just showboaty. You'll get one from the prosecutor on behalf of the government and the other from the defense. So nobody's testifying at this stage. There's no evidence being presented at this stage. It is just the prosecution's turn to prove that the defendant is guilty, and they have that burden of proof. So they go first, and they will give a very detailed statement that's often more detailed than what the defense will say. When the prosecution presents, they will talk about typically the facts of the case from the prosecutorial perspective. They will walk the jury through what the government or what the prosecutor is trying to prove. They will provide evidence of what the defendant did, the who, what, where, when, why, how. But again, they're not presenting physical evidence at this stage. They will then allow the defense to respond with an alternative to whatever facts the prosecution brought up. They can rebut the evidence that was mentioned, and pretty much this is their turn to plant a seed of reasonable doubt based on the opening statement that the prosecutor made. Once this is done, there is witness testimony and cross-examination, and this is essentially the heart of any criminal trial, which is the case in chief stage. This is when each side presents their evidence to the jury. The prosecution will intentionally bring evidence to the jury that will prove beyond a reasonable doubt that the defendant committed the crime. And at this point, the prosecutor will call their witnesses or experts that they may have to testify. They may introduce physical evidence, and this can be anything like pictures, text messages, medical reports, documents, weapons, anything. When either a prosecutor or defense attorney calls a witness, the witness testimony process is typically straightforward, and it will be, let's say the prosecutor calls the witness to the stand. That person will be asked to take an oath. Do you swear to tell the truth? I'm sure you've all seen that in Law and Order or some other show. And you can be charged with perjury if you make false statements under oath. But the party who called the witness to the stand will question them through what's called direct examination. They will prompt information from the witness with questions in an attempt to strengthen their argument and strengthen what they are trying to prove in the case. After the direct examination, the opposing party, so let's say the prosecution called the witness, they direct examine. Now it will be the defense attorney's turn, and they will cross-examine that witness. This is meant to poke holes in anything that they said, or maybe to clarify something that might actually strengthen their side of the case. And then the original party who called that witness can then cross-examine again to try to clean up after any damaging effects of the initial cross-examination by the opposing party. This is the part where you're going to see a lot of objections. The judge will either sustain it or overrule it. And these objections can happen because maybe something that shouldn't be admissible was admitted. Maybe a witness was led. Maybe there was hearsay. It could be an objection for anything. But this is actually a really important part of the case, especially on the defendant's side, because if there is some kind of misconduct in any way, maybe the prosecution was leading a witness, this would leave the defense an opportunity to then file for an appeal. So this is a really critical part of trial. Once the government and prosecution side is done with their case in chief, the defense can then present their own evidence. The defense doesn't always have their own case in chief. They don't always present their own, but they can. Sometimes you'll just see the defense make key points through cross-examining the government's witnesses and kind of poking holes in whatever they're trying to prove through whatever witnesses they called. They will try to highlight any insufficient evidence maybe. And if the defense does choose to present a case, the prosecution would then have the opportunity to do the same thing. So the defense would call any witnesses and they would do direct examination. The prosecution would then be able to do any cross-examination. So it would be the same thing, just reversed. Once both sides are done, I'm sure you've seen this on TV before, prosecution rests, defense rests, everybody rests, they're all done. This means that there's no more evidence that's going to be presented to the jury in court before closing arguments. And closing arguments are similar to the opening statement. It offers both sides to sum up the case, recap any key evidence or a lack thereof that might favor their side. And this is the last chance for either the prosecution or the defense to address the jury before the jury begins deliberations. Again, it is the prosecution's job to show why there is enough evidence for the jury to find the defendant guilty beyond a reasonable doubt. But then the defense, their job is to show that they have not done that. They have fallen short of their burden of proof. Jury instruction is a process in which the judge gives the jury a legal set of standards to decide whether the defendant is guilty. The judge decides what those legal standards are and what legal standards apply to this particular case. This is ultimately based on the criminal trial as well as the evidence that was presented during trial. This process typically takes place with input and arguments from both the prosecution and the defense. But then the judge will instruct the jury on any applicable law that the jury must adhere to arrive at their conclusion, whatever that conclusion may be. At this point, the judge will also explain what things are, like guilty beyond a reasonable doubt. The judge will define the elements of the charged crime. Maybe the judge will define elements of other related crimes. The judge will explain the findings that the jury needs in order to convict the defendant of the crimes. And before the case goes to the jury, the trial court judge will outline each juror's responsibility. This is going to be the main topic in my interview today with Katrina, but not using outside resources to research the case. One of the biggest rules as a juror is you are only allowed to look at what is presented to you in court during trial. You're not allowed to look at anything else. You're not allowed to do any of your own research. Jurors are also not allowed to discuss the case outside of the jury room, and all jurors must agree on the verdict in a criminal case. The jury then selects a foreperson, and this is the spokesperson that will track the discussions through deliberation. The jurors will attempt to agree on whether the defendant is guilty or not. Deliberation it can last anywhere from hours to weeks to months. But once they reach the verdict, the foreperson informs the judge. The verdict is read in court. All states require a jury in a criminal case to be unanimous when they find the defendant guilty or not guilty. Failure for that could lead to a mistrial. Needless to say, while it is all of our civic duty in the United States, I can't imagine how overwhelming and traumatizing it must be to serve on a jury for a murder trial. And this is something that thankfully Katrina has a lot of insight on. Katrina, thank you so much for coming onto the podcast.
I'm excited to be here. I'm looking forward to it.
Can you tell us a bit about yourself?
Well, goodness, once you've been around for a little bit, it's kind of like, what part of me do you want to know about? The cookie cutter answer is I live in Hot Springs, Arkansas, and been married going on 28 years now. I have 5 children. 2 are biological and 3 are adopted, 2 from foster care, 1 actually as an adult. And then my real job is I'm a financial advisor, investment manager, but At the beginning of 2023, I published a book that then kind of opened up some speaking opportunities. And so now I do a little bit of that on the side. So that's me in a nutshell.
Can you walk us through the moment that you were selected as juror number 11 and what were your initial thoughts and feelings?
Sure. Well, this was the first time I'd actually been selected. I'm an extremely busy woman, wife, mom, professional. And when I got the notification that I needed to report for jury duty, it was actually during my daughter's wedding. And so it was kind of like, so I was in just overwhelmed mode anyway. And I was also kind of walking through some very, very just hard things with a couple of my other kids. So I was already kind of in overwhelmed mode. So I get this and I was like, well, that's awesome. I certainly don't have time for that. And then we get to the courtroom and they give a brief overview of the case. And the case it was a murder trial. The defendant was being charged with first-degree murder, and they said that they were expecting it to take 4 or 5 days. Well, then of course I was like, oh my gosh, I can't just step out of my life for 4 to 5 days with no notice. I mean, I don't have time for this. But then I kind of got into this mode of, you know what? This is a very important responsibility. And I should be honored that I am being tasked with this. And so I kind of got into this mode of, as we went through the voir dire process of, you know what, I can do this. And this is important and I can do this. And then, of course, as they get the pool narrowed down to, I don't know, maybe 20 to 25 people, they basically just put all the names in a hat and they draw out 14. 12 is how many sit on a jury, but then they draw a couple extras for alternates. And so when they got to juror number 11, my name was called. So it was kind of like, well, I'm almost. I was like, I started thinking maybe I am able to kind of walk out of here and get back to real life. But no, I wasn't fortunate.
What was going through your mind when you realized it was a murder trial? I imagine that that's probably really overwhelming to consider that you are now deciding the fate of somebody that potentially committed murder.
Absolutely. Trying to decide any case is a huge responsibility. But when we're talking about a murder trial and literally putting somebody in prison for the remainder of their life, and then you also have the victim's family and being able to feel like that they're able to get justice. So absolutely, it was a huge responsibility and one that I did not take lightly whatsoever. And it was something that as I sat in the deliberation room, I really struggled with. And in the book, I'm very vulnerable about how much I struggled with it. I was even very emotional. And I struggled with how easily juror members could be swayed by groupthink or just peer pressure, or whereas I was kind of like this total mess over making sure we got this right and did it correctly. Other people, it seemed like they were more interested in just getting home and eating dinner and checking the basketball scores. And it was hard. It was very, very hard for me. And when it came to the point where we had to say guilty or not guilty, I didn't realize how difficult it would be for me to utter the words guilty about another human being. I went into it with very much our judicial system is all about truth and justice. And I came out of it realizing there is a lot of manipulation done. Facts are presented in cherry picked manners, and there's a lot of power plays that go on. And it was very difficult for me because as a jury member, I felt like we were tasked with this huge responsibility and we're not allowed to know everything. We were only allowed to know these cherry picked pieces. So we didn't have the full picture. And not only were they cherry picked pieces of evidence, but they were delivered in an emotionally manipulative way. Sitting in a murder trial, I was like, oh my goodness, do these prosecution and defense, do they have like minors in theater? they, which I understand the need that they have to hold the attention of the jurors and to try to drive home points. But at the same side, I was like, I don't want a dog and pony show. I just want facts. And I struggled with, I could only consider that which was presented when I knew there was so much more to the story.
Can you walk us through the case, how the case was presented by both the defense and prosecution, and your thoughts on how the defendant presented during trial?
Sure. It was a murder in the first degree. Prosecution, really the state, they really needed to prove intent to kill. She pulled that gun out with the intent to kill her husband. I didn't realize, of course, you're all supposed to go in with the understanding innocent until proven guilty, correct? And I absolutely walked in there with that innocent until proven guilty. What I did not realize is that then leaves the burden of proof on prosecution. So, because the burden of proof is on prosecution, they are given the upper hand. But then to add to that, in this particular case, the state or prosecution had 4 prosecutors on the case, whereas she just had her one defense attorney. So each one of those prosecutors were able to take just a specific element of the case in trial or evidence or whatever. And then when it came time for them to call their witnesses, they had 14 witnesses that were called. Every single one of them, there was none that were there to address the issue at hand, which was intent. It was only addressing the fact that she killed him, which to me, I'm like, okay, we knew that before we even started. One of the quote witnesses was actually, it was to me very obvious she was an estranged daughter of the victim, but she was called as a witness. She had not spoken or seen her father in multiple years, so had no ability to testify to, there were allegations that he was an alcoholic, that he was abusive, but none of that was allowed to be brought in as evidence or talked about. And she wouldn't have been able to offer any testimony in that regard anyway, because it was obvious she did not have a relation with her father. But regardless of their relationship, no doubt having your father killed is traumatic, but her only purpose was a manipulation tactic on the prosecution to have her upset and emotional on the stand. And I took offense to that, not to take away any of her experience, but it was, to me, it shouldn't have been allowed. And then things like displaying an autopsied body of the victim while they were giving statements. I mean, that's simply to draw emotions from the jury. So 14 finally get to defense. She had 17 witnesses, but of those 17, only 3 were allowed to speak. As they called each one, the prosecution would immediately object to their testimony. It would be sustained and they weren't allowed to speak. But we as the jury, who again are tasked with the responsibility, were not allowed to know who these witnesses were, what they were going to testify about, or why it was objected to their testimony. So again, I'm left with, we aren't getting the whole picture and we don't even know why. If you're going to task us with ultimately being a judge in the case, judge knows why these witnesses are being objected to and what they were going to testify to. And we are the judges in this case, but we were not allowed to know that. I felt like we were kind of treated as ignorant, like we can't understand the rules of law and evidence, and therefore we aren't even going to allow you the opportunity to vet these witnesses on whether they're reliable or credible or relevant. So that further explains why I struggled so badly, because my emotions and my gut and my heart wanted one thing, but I'm like, okay, I've got to trust in our judicial system, and I am forced to judge this case and issue a verdict and sentencing based only on what was presented in the trial. And that's exactly what I did, but ultimately was martyred for it.
It's interesting that testimony that indicates that, not to diminish that the husband was a victim, it's not advocating for somebody to end up murdering somebody in this instance. But when you're thinking about issues with alcohol consumption and abuse, those are 2 things in a domestic situation that can impact somebody and maybe cause them to commit murder. So it's interesting that that was not really allowed. because that could be such a big piece of the component as to why it could indicate self-defense in her mind.
Sure. The only thing that was allowed is the toxology report from the coroner, and that he did have a blood alcohol content above the legal level, and it was the middle of the day, but the argument was he was at his home. Anybody is allowed to drink at their home. But so we ended up issuing a unanimous verdict. Not guilty on first, but guilty on second was where we as a jury came up with. It was after the trial was said and done that another jury member went up to the courthouse and filed a juror misconduct complaint against me. And that's what started the whole snowball of nightmare for me. And so when that happened, it was the defense attorney that grabbed hold of it, wanted contempt of court against me and a mistrial granted. But what I was going to get at was, of course, I then at that point, I'm like, well, at that particular trial, the defense attorney kept arguing that how the prosecution continually denied, objected to, I think, 403B evidence, I believe is what it was called. And so, of course, I'm like, well, what in the world is 403B evidence? And I go and look it up, and it is any evidence that speaks to the character or of a person based on like prior acts, that kind of thing. And so that, of course, I was like, okay, so obviously all of these witnesses, they were going to speak to his abusive or alcoholism or that kind of thing. The theory or the idea behind why those aren't allowed is it's like, okay, well, just because he may have been abusive or an alcoholic does not mean in that particular moment he was being abusive. Of course, I'm like, history is indicative of current and future behavior. Even if he was not in that moment, if he had been in the past, she absolutely could have believed that she was in danger. So it's a flaw. It's a loophole there, and an unfortunate one. One of the only witnesses that was allowed to speak on her behalf was a PTSD kind of expert that basically said she showed signs and symptoms of PTSD. But what wasn't able to be discussed is where that PTSD came from.
Can you explain what facilitated the juror to file an accusation of misconduct against you?
So, like I said, I was struggling greatly with this, feeling like we didn't have the whole story. When you're on a jury, they kind of pound it into your head that don't research the case, don't look up anything on the case, don't talk about the case. We all know that. Well, I didn't have any problem with that because after sitting in a trial for 4 days, I could guarantee you I knew more about the case than any old, and also the incident had happened 2.5 years prior. So there wasn't anything that made any sense to even attempt to research. But what I didn't really, and you also said don't research any. They identified the parties to the case as everybody there in the courtroom. Well, I felt like, you know what? The victim is not present. I think I could argue. I mean, he's not there, right? And I know absolutely nothing about this victim other than his wife shot and killed him, and that there's allegations that he was an alcoholic and abusive. And so I typed his name into my computer, spent maybe all of 5 minutes, found absolutely nothing. And, I talk about this in the book, and I was able to like, Katrina, you're going to have to just trust that this is how the judicial system works for a reason. And I shut my computer, I went to bed. The next day was deliberations. And after we had already decided, we'd already let the bailiff know that we had come to a decision. And I was just kind of in the venting, emotional vomiting in the jury room. I made the comment to nobody in particular that I struggled with the fact that we really didn't get a chance to really know the victim or the defendant's stories. I said, I tried to look up something about the victim. I couldn't find anything. So that the other jury member went and said that I had brought outside information into deliberations. One, it wasn't deliberations, and my quote outside information is that I didn't find anything. So that was what it was. So like I said, we found the defendant not guilty on first degree, guilty on second. And it was her attorney, the defense attorney, that was arguing for contempt on me and a mistrial granted. But by doing so, he was actually opening his client up to first degree murder all over again. And so I was kind of like, what is happening here? But then not only that, as they brought us we get this letter in the mail saying there's been allegations of juror misconduct, everybody has to come back. So then it's kind of like, oh my gosh, what in the world's happening? We're all called back. We're sequestered back in the jury room, and they start calling us out one by one. Everybody's there, all the parties of the case and witnesses and all that. Well, they saved me for last to come out and testify. So as I sat in that jury room by myself waiting, I was like, has something to do with me. And I get out there and he just slandered me, lied about me, ripped me up one side, down the other. But then once they dismissed me from the stand and they had me sit in the audience section, and then the counsels went back and forth arguing with the judge as far as how to move forward. It was disclosed that there were only 2 jury members that even had any recollection of me even making any statements like that. But yet, based on that, the judge granted a mistrial. It's just bizarre. It very much felt like this pawn in this political game that the particular parties were playing.
Yeah, that's a lot. It's interesting too, because you didn't introduce any information. At the end of the day, I understand why that rule exists. You're not supposed to have any exposure to anything outside of the investigation and what's presented to you. But then on the flip side of that, they're picking specifically what is presented to you. So how are you making a truly informed decision?
And I do understand the rule to an extent as well. But my problem is that rule came about during a time when the only information available to jurors would be outdated newspapers and secondhand information from local townspeople. Now we literally have non-biased factual information at the tips of our fingertips. And that information absolutely is probably accessed for a judge in judge cases. But whenever I ended up getting my attorney and I had that first meeting with him, he said, of course, I'm emotional, and especially when he was kind of like, Katrina, you're looking at a year in jail. And I was like, it's like all the oxygen leaves the room. And he said, Katrina, you are not a bad juror. You're a dream of a juror, because it's obvious that you walked in innocent until proven guilty. He said, when you have a multiple day trial, are there jury members that probably look stuff up? He said, absolutely. It's too easy to. And like you say, it's, you're not going to Facebook. I mean, it was a court document portal that I had typed his name into. And he says, is it possible that jury members possibly mention that within the jury room? And he said, probably. He said, but ever in the history, at least of our particular county, has another jury member come back and complained? He said, no. And then to push it a step further and it result in a mistrial, he says, never in the history has that happened. So they weren't even real sure what to do with me, like how to even proceed with it. So the defense attorney was totally opening his client up to first degree murder all over again. But not only that, his argument was that since I said I didn't find any information, that it was like I had prejudiced the other jury members by the defendant did say that she was abused by him. But if I didn't find any information, then that prejudices his client, because the idea is me saying, well, she must be lying because there's no information. I'm ultimately the reason that she didn't get first degree. I was the one arguing for her. And actually, it turned into this whole circus thing. When we went to my first hearing, my husband was talking to a newspaper reporter that was there, and he called out the defense attorney on a couple of lies that he had said about me. And then also had said, my wife was the one arguing for a lesser charge. So that got published in the paper. Well, then the state ended up coming back and saying that there are no grounds for there to have been even misconduct. But of course, it was already done.
What was the outcome of this complaint process, and how did it change your perspective on the whole judicial process and serving on a jury?
Well, so one of the outcomes is the judge basically banned me from ever serving on jury duty again. I was like, oh, okay, can I get that in writing? So that was one of my quote consequences, that I'm not allowed on jury duty. I mean, I guess just for my county, I wouldn't think outside my county they would know. But yes, I was charged with contempt of court. But here's the interesting thing. So, whenever we went to the whole issue of juror misconduct to be heard, and the judge, and another little piece of the craziness, the original judge for the murder trial ended up recusing himself from it. And so it was a different judge that stepped in to determine contempt and mistrial. So at the end of that, when she's like, it's obvious she's in contempt, and because I think the defendant deserves a fair trial, I'm granting a mistrial. And she hands me, has a piece of paper given to me that has a date I'm supposed to show up to court, and it says show cause on this date. So then I go to my attorney and I'm like, what does this even mean? Like, is this where I go and plead guilty or not guilty? And he said, Katrina, you've already been found guilty. This is your sentencing hearing, and you're looking at a year in jail. Anything he said after that was not discernible. And so I'm like, what do you mean I don't have an opportunity to say I'm guilty or innocent of that? So that was one piece of it. Well, since this had never happened before, like I said, they didn't know what in the world to do with me. And my attorney had told me up to a year in jail. But then whenever I had my hearing, the judge, once she was done berating me, and she has a reputation in our town, and I felt like I was hoping that I would see things differently, but no, she lived up to her reputation, and I don't have to say a word derogatory about her because I put the court transcripts in there, and you can draw conclusions yourself on what kind of person she is. And then I'll say that as soon as my book published, she had a spur of the moment retirement, didn't even finish her term. I don't know what the correlation is there, but interesting nonetheless. So she ended up saying that it's up to 30 days in jail. Well, then I was left there saying, wait a minute. My attorney told me a year, and I've been mentally preparing myself for a year this whole time. So if it's only 30 days, can I say a few more things? Because now that doesn't sound so bad. My attorney, was he lying to me in order to put fear in me and to pay the retainer for him? Or did he genuinely not know what the maximum charge was? I don't know. But what she ended up doing was, when you're a juror, you're paid. It's minimal, but you are paid. And so you're paid one rate anytime you're called for jury duty. But then if you actually get selected, you're paid a little bit higher rate. So she basically said, since I had completely wreaked havoc on the justice system and wasted so much time and resources of the state, that one of my consequences was I had to repay all of the jury fees, which you're like, well, they're not paid that much. Well, there was like 50 plus that showed up that day. And then it was also, they have like 50 that first day, but then you've got the 14 that were selected, and then it's a 4-day trial. So absolutely, it was a significant sum of money. So that was one thing. And then it was kind of a circus, like nobody at the courthouse knew what to do. And she required me to pay it right then, like no payment plan, nothing. I had one person go like, how is that even legal? If you can't pay it that day, would you have gone to jail? I don't know. I was fortunate that I had the funds to pay, but then nobody knew what to do with this check. And then another little piece that I don't, or maybe I did include it in the book. I don't know. It took them like 4 months to cash it. And I almost started thinking, I'm going to like cancel it. Like, I think they're like, they don't know what to do with this check. So my attorney had told me, he said, Katrina, so I was charged with contempt of court, a criminal charge. But if you look me up, it is nowhere to be found. And he had told me before it was all said and done, he said, this is all so bizarre, you probably won't ever find this charge on your record. And he's right. But I'm kind of like, obviously, I don't want it out there. But at the same side, how are they able to do that? The power that particular individuals have, judges mainly. So my advice to anybody involved in the justice system, especially if you're a defendant, find a good attorney, a really good attorney that knows all those loopholes and rules.
If you could change one aspect of the jury system as it is today, based on your experience, what would it be?
To me, I kind of go back to we should be able to have access to any and all information. If you're tasking us with the responsibility to judge another human being, sentence them, issue a verdict and sentence them, then you should also have enough faith in us that we are able to discern credible information versus reliable information, whether it's relevant. We should have access to any and all information.
You mentioned that the defense attorney was the one that wanted the mistrial, but now you have a relationship with the defendant. Can you explain how that happened?
Once I had written the book and I was getting ready to publish it, I don't use any names in the book, but obviously the defendant is a kind of a central character in the story. So I reached out to her to let her know that I was writing a book, and she ended up responding and said, God's used you to save my life, and I'm forever going to be grateful for you. And that's been right at a year ago now. And she'd been a piano teacher for decades. She's got a master's degree in music. And she actually is teaching one of my sons piano via video sessions and stuff. And we talk regularly.
You faced significant legal and personal challenges. Was there a specific point where you felt like giving up? And if so, what has kept you going?
Oh, wow. Gosh, probably daily would probably be a little too frequently, but goodness, probably weekly. My specific story, especially with the jury duty and stuff, I've yet to run into another person that has had that exact set of circumstances. Now I'm in the foster adopt world. I do have a fairly large circle of foster and adopt moms who have walked hard roads with their kids who can relate to that, but everybody can relate to the experience of basically feeling like life's kind of sucker punched you, or you've had the rug yanked out from underneath you. And what I've kind of the cornerstone of my book is my faith. And in that true faith is continuing to put one foot in front of the other, even when nothing makes sense. Like you've got these beliefs, right? This faith that you have, and like nothing is lining up, like nothing makes sense. And what kept me going? Did I want to give up? Absolutely. Did I allow myself to feel those hard emotions? I don't try to mask it. I've always been very open and vulnerable and transparent. And I had over the years people tell me, like on my social media, our journey with our adoption and raising these boys, and everybody likes to hear and see and tell the rainbow stories of adoption, the beautiful side of it. But the reality is every adoption, no matter what kind it is, there is a component of loss and grief there. And I've always been very open about telling the whole story. And over the years, people would say, you need to write a book. You need to write a book. Well, I was like, I don't have time, and I don't know why people would be interested. And then whenever I walked through this thing with the court system, I was like, okay, I'm going to write the book. And I interweave in it some of the stories of a couple of my boys in the book. But it's allowing yourself, I say, to kind of like sit in your ash pile and cry, to yell if you need to, be angry with God if you need to, ask the hard questions. But then my continuous theme throughout the book is to rise, continue to rise. And in fact, whenever everything was finally done and I had my last day in court, I went from court to get a tattoo. And I know your listeners can't see it, but it's a phoenix, because that was kind of like my theme is just keep rising, no matter what life throws at you.
Looking back, what advice would you give to somebody who might find themselves in a similar situation as you were during the murder trial?
The reality is, if you're going to serve on a jury, if you are going to struggle with making a decision based only what is presented in a trial, then you might as well say that daring voir dire and get yourself excused. Because yeah, and had I, hindsight, yeah, I probably would have been like, I've got a problem here. And actually, like I said, they picked two alternates, and I was struggling so greatly that, like I said, I would have gone with hung jury before I went first degree. Well, both of those alternates had already been used up. Two jury members ended up getting dismissed. Of course, we weren't told why. There was a rumor that somebody had said they were misbehaving. Maybe it was that same as juror number 8. Maybe she had tattled on them, or who knows, but they had been dismissed for undisclosed reasons. So we had no alternates left. So I'm wondering if there'd been an alternate, I would have felt like I could have say, I'm stepping back, but I didn't have that ability because there were no alternates left.
The last question I have for you is, what is next for you? Do you have any upcoming projects or goals that you're excited about?
Excited is probably the wrong word. Scared, but have started having some opportunities to just do speaking. And I don't have any intention or plans of stepping away from my career as a financial advisor, but I'm kind of enjoying the something new and different and a little bit scary and character stretching to do.
Katrina, thank you so much for coming onto the podcast. It's been great getting to hear more about your story. Can you tell everybody where they can find more information on you?
Sure. My website is KatrinaLRobertson.com. You can see my book on there, or the easiest, but it just will bring you to a link to Amazon. Amazon's the easiest place to find it. It's Juror number 11, and that's #11. And the subtitle is A Memoir of the Broken Justice System and Rising Through the Trials of Life. So it's there in ebook, paperback, hardback. And then I do have an audio version out there. Full disclaimer, I recorded it myself, and I am by no means a professional voiceover, but it was important to me to have it in my voice since it was my story. So if you're a regular audiobook listener, you may be disappointed in the quality, but I did the best I could, and it is an option out there. So yeah, that's where you can find me.
If you liked what you heard today, please hit the subscribe button wherever you listen. Give me a review, 5 stars, and I will love you forever. You can find me on social media everywhere at f.pod except for Instagram. It is f._pod. Website, f.pod.com. Patreon, f.pod for exclusive content, ad-free episodes, early episodes, bonus episodes, archived episodes, free stickers, and a ton of other shit that I am too lazy to name right now.